You can come forward as our helpful cleaning is going on. I'll call the third case for the day, John Thompson versus Microsoft Corporation, 20-50218. Counsel can begin.
May it please the court. My name is Avi Moshenberg, and I, along with my co-counsel, Nick Lawson, represent the appellant, John Thompson. The court should reverse the trial court summary judgment because there's evidence in the record to support Thompson's discrimination and failure to accommodate claims. My co-counsel will address the discrimination issue, and I'll explain why the lower court erred in granting summary judgment on the failure to accommodate claims. And it's really for two reasons. First, a job reassignment program is not a reasonable accommodation, especially when accommodations could have been made to Thompson's job. And second, Microsoft did not engage in good faith in the interactive process as it was required to because it reneged on the accommodations it had agreed to provide. Now, John Thompson was an enterprise architect with Microsoft. In January of 2016, he revealed to his boss that he has autism. His boss responded that he should seek a different career, and then his boss removed him from a pool of enterprise architects that are eligible to work on other projects. The boss even testified that he did it because Thompson has autism. Now, while Thompson was in limbo, he sought reasonable accommodations from Microsoft so he could get back to work. Microsoft agreed to most of the accommodations that he requested, but not all, and Thompson ultimately said those were fine and he would make alternate arrangements. But then Microsoft reneged on those accommodations it agreed to provide. It removed Thompson from the enterprise architect position altogether and placed him in a job reassignment program to find a job that didn't exist. That's not a reasonable accommodation. And that brings me to my first point, that a job reassignment program is not a reasonable accommodation, especially since accommodations could have been made to the prior job. Now, what this court has told us is that the process of seeking a reasonable accommodation starts with the disabled employee requesting reasonable accommodations. And at that point, the employer has a lot of options available, which primarily include making changes to the current job to accommodate that disability. And as a last resort, the employer can transfer that employee to another vacant existing position. While those are remedies available to an employer, what the ADA does not recognize is that a job reassignment program alone is a reasonable accommodation. That's simply not an option that's available to employers. And here it's especially problematic because what this court told us in cases like Jenkins versus Clecco Power is that first you need to find out whether there are accommodations that could be made to the current job before we try the last resort of a job reassignment. And of course, there could have been accommodations made to Thompson's job. The record shows it. In fact, Microsoft agreed that there were certain reasonable accommodations it could make. But then it reneged and decided to put him in a job reassignment program, which of course is not a job reassignment. But for a job reassignment to even be considered a reasonable accommodation, not only does it have to be a last resort, there actually has to be a vacant existing position that the employee is qualified for. And there's nothing in the record to show that there was any vacant jobs that Thompson was qualified for. And it's just the opposite. The record shows that there were no jobs and that Thompson was essentially asked on his own initiative to go find something that works for him. And what the district court in the District of Columbia recognized is that having an employee look at a job reassignment program and try to find something else on their own initiative without any help, and a job reassignment program that's available to every other employee, that is not a reasonable accommodation for a disability. And so that's precisely the problem, that not only were there accommodations that could have been made to Thompson's job as an enterprise architect, not only was job reassignment program not a recognized reasonable accommodation, but there also wasn't an actual job, a vacant existing job that justified the reasonable accommodation of a job transfer, which is what this court has told us is required. But the reality is, because there were no accommodations made to his EA role, the analysis really can end there. And the fact is, they could have made accommodations, but they just didn't. And that brings me to my second point, that Microsoft, the evidence shows, the reason Microsoft didn't give the accommodations it had first promised to give was that it wasn't interacting in good faith. That evidence can be construed that they never actually intended to provide those reasonable accommodations. And what this court told us in cases like Dillard versus City of Austin Limits is that the interactive process is a good faith process where the employee and the employer are working together to try to find an accommodation that works for the employee. And both sides, it's a two-way street, as this court said. Both sides are supposed to try to find a solution that works, and it's not supposed to be what is the first offer and let's hope everyone agrees on it. It's supposed to be a back and forth. It's even supposed to be a trial and error process where the employer is supposed to try to make accommodations, and if it doesn't work out, try new accommodations. That's what the interactive process is supposed to look like, and that's what Thompson did, and that's what Microsoft did until it reneged. It's supposed to be a back and forth where they land somewhere. They did land somewhere. The problem is that ultimately Microsoft decided that where they landed isn't where they wanted to be, and so they just pulled out of a deal when there could have been accommodations made to Thompson's enterprise architect role. That's not interacting in good faith. A jury could easily find that. And a jury could also find that accommodations could have been made to Thompson's role as an enterprise architect because Microsoft agreed to those accommodations. That's the evidence in this record. And the reality is, on a summary judgment review, that's enough to go to trial. And it's precisely what we're asking for this court to do, not to say that we win under the ADA as a matter of law today. We just want the opportunity to remand this case for trial and prove these facts to a jury. And it's precisely for these reasons that we ask that this court reverse the trial court's judgment.
All right, counsel. You may proceed.
Thank you, Your Honors, and may it please the court. As Mr. Moshenberg stated, I'll be presenting argument on Thompson's discrimination claim. And I'm going to focus my argument on two errors made at the district court level. The first is when the district court erred in finding that Thompson was not subject to an adverse employment action. And the second is finding that Thompson did not present evidence of pretext. Thompson was subjected to two adverse employment actions. The first, when he was removed from the EA pool, and the second, when he was placed into the job reassignment program. Now, his removal from the EA pool meant that Thompson was no longer eligible to receive other EA assignments. So he wasn't working with clients, he wasn't working with the rest of his team, and he wasn't doing any of the EA job duties that he had before in advancing his skills. And when he was placed into the job reassignment program, he was terminated from the EA position altogether, and his only job at that point was to find a new job. As this court has recognized in Rizzo, Alvarado, and Forsyth, all cases cited in our briefs, Your Honors, a adverse employment action can occur when job duties are changed for the worse, when an employee is transferred to a position that's less prestigious, or looked over for a position that's more prestigious, or even when they're placed in a position where their career development opportunities are diminished. And that's exactly what happened with Thompson here.
Well, you talk about Rizzo. What of the distinction here, which is part of what your colleague was talking about, with being put into a program to see where he might suitably be placed. So he wasn't actually transferred to something better or worse or whatever else. Isn't Rizzo distinguishable on that basis? And I'm wondering where that leaves us on your argument.
No, Your Honor, I don't think that it is, because when he was first removed from the EA pool, he was done performing EA duties at that point. And I think that's exactly what Rizzo was talking about.
But we don't know what his new duties would be, if it's pretextual and whatever else, as your side is claiming, or at some point it becomes not reasonable efforts on Microsoft's part. But nonetheless, that initial change, insofar as this record shows, would seem to be an effort to find a new location for him, which might be equivalent to what he was doing before. And that's what I see as the difference with Rizzo.
Okay. Your Honor, could you repeat the question? I'm sorry, I didn't.
You're having, it's not just a screen and whatever. Advocates often can't understand what I'm asking. I'll do a little better. I'm just wondering if Rizzo is distinguishable because at the stage that you're talking about now for your client, there was no new job for him, better or worse. It was an effort to find out where he could best fit in this interactive process. So it doesn't seem to me anything adverse has necessarily happened.
Well, sure, Your Honor. I think then where Rizzo might not apply directly, Alvarado and Forsyth do. I'll start with Forsyth. Forsyth is the case in which the undercover detectives were transferred to essentially uniformed night policemen. And this court found that that was basically a step backwards in their careers. I mean, they had the same position. They were sergeants, and their pay didn't change, but that position wasn't an opportunity for career development. And surely when Thompson was removed from the EA pool and not working with any clients, he had no opportunity for career development at that time.
You proceed.
Sure, Your Honor. Now, there are two primary errors that the district court made with respect to adverse employment. The first is when it failed to analyze the move from the EA pool, the removal from the EA pool altogether. The district court focused instead on placement into the job reassignment program, and that was an error. The second is when the district court found that the placement into the job reassignment program was itself a reasonable accommodation as opposed to an adverse employment action. And as Mr. Moshenberg explained, the job reassignment program was not a reasonable accommodation. For one, he wasn't assigned a new job. And for two, it has to be a last resort if an assignment is going to be a reasonable accommodation. And the evidence here is that Microsoft never provided any reasonable accommodations, although they agreed on them, for Thompson to stay in the EA role in the first place. So it wasn't a last resort, the job reassignment program itself. And Your Honors, that brings me to my second point, which is that the district court erred in finding there was no evidence of pretext. Now, as an initial matter, we don't have to speculate as to why Thompson was removed from the EA pool, because his supervisor, Garcia, told us why. He said it was because of his disclosure of autism. And in fact, as soon as he found out from Thompson that he had autism, he told him he needed to seek a new career. Your Honors, I believe that's direct evidence of discrimination on the basis of his disability. But even if we indulge Microsoft's argument that he was pulled from his EA duties because of poor performance, that argument fails under scrutiny. For one, there's evidence that he performed well. And for two, we know exactly what Microsoft does when it has a poorly performing EA. They provide them training. This is what Garcia testified to. But they did not provide training to Mr. Thompson. A reasonable jury could infer that the fact that Microsoft deviated from its ordinary practice of providing training for poor performing employees meant that poor performance was not the reason that he was pulled from the EA job. And Your Honors, it's for these reasons that we'll ask you to reverse the lower court's decision and remand the case for a jury trial on the merits. Thank you.
Good morning, Your Honors. Karson Thompson on behalf of Microsoft Corporation. I feel a bit like Dr. Lecter in the middle of the room in the plexiglass box here, but I appreciate the court accommodating us to allow us to be here in person today.
Nothing further that happens will make us think you're like him.
Absolutely. I'd like to start with the failure to accommodate claim. Actually, before we get there, this case started as essentially a case of double its size, a case of 8 distinct but related claims, a full set of the same 4 claims that Mr. Thompson focuses on the enterprise architect job, also raised during his time as an account technology strategist. That is, failure to accommodate, disability discrimination, hostile work environment, and retaliation. By the time we got done with the summary judgment briefing, Mr. Thompson had abandoned all but the 3 claims that remain in this appeal. And while Mr. Thompson would like this court to sort of ignore the history of the first half of this litigation, it's important that the court not do that, because what the evidence shows is that by abandoning, that what happened was that Mr. Thompson has abandoned an identical set of causes of action because the undisputed evidence established that when Mr. Thompson first disclosed his disability, Microsoft engaged in good faith in the interactive process and ultimately accommodated him with what Mr. Thompson at the time described as his most preferred accommodation in allowing him to go into the job reassignment process and ultimately be transferred into the enterprise architect position that he is still in today.
Counsel, it seems to me that the summary judgment record supports, you can tell me if it's disputed, because it might not have been relevant in the judgment, so perhaps it could be disputed, that this was a forced placement in the EA position in Austin, that he wasn't competing for it necessarily, but wherever he had been before, and part of the accommodation process is to have, seems to me, allowed him to get the kind of job he wanted and just let it play out. Tell me about what the record says about that process that got him into Austin, into the EA position in the first place.
That's ultimately an accurate picture of what happened, Your Honor. Forced placement was the language that Mr. Thompson's manager used to describe.
How that affects the issues we're looking at, and accommodation and the reasonable efforts thereafter or not, of Microsoft to work with someone that they may not have initially thought would work in this position at all. And I don't know which way that cuts.
I think the issue that it most speaks to, Your Honor, is the issue of qualification. And what that forced placement allowed to happen was, because Mr. Thompson told Microsoft, I don't want my new manager to know that I have a disability or that I need any accommodations in order to perform the essential functions of my job, he was put in that forced hire scenario. And when his manager looks at his qualifications on paper, it appears that he is qualified to do the job. But what the manager ultimately finds out from Mr. Thompson himself is that because of the way his disability impacts him, he has challenges performing all of the essential functions of that job. Mr. Thompson confirmed that himself. For example, on page 1330 of the record, the court can find an email exchange where Mr. Thompson is going back and forth with the benefits lead who's managing that process, and he says, essentially, there are no essential functions of this enterprise architect job that I can't perform, provided that I have the accommodations that I am requesting. And what Microsoft ultimately determined was that several of those, not all, but several of those requested accommodations were not reasonable. In the lower court, Mr. Thompson never contested that determination, and he has waived any ability to contest it in this court. Microsoft's business judgment was not questioned below. There was no potential or suggested dispute about Microsoft's determination of the unreasonableness of several of those accommodations. So opposing counsel's suggestion today that there were reasonable accommodations that could have been made runs headlong into that waiver problem, because Microsoft was willing to provide a number of accommodations. There's a chart, I appreciate the court can't read it as I hold it up here, but it can be found on page 274 of the record, that illustrates the numerous accommodations that Microsoft was willing to provide, but also the few key requested accommodations that it wasn't able to provide, because those accommodations would have excused Mr. Thompson from performing essential functions of his job. So, for example, one of the accommodations that Mr. Thompson requested was that he would have some other employee assigned to handle incoming requests from clients, review and analyze those requests, triage them, break them out into constituent tasks, prioritize those tasks, and then assign those tasks out to him to be completed. And Mr. Thompson's managers looked at that request and said, that is the job of the enterprise architect, to go through that process of triaging and prioritizing client requests. And so asking us to provide someone else to do that for you is asking us to provide somebody else to do a core component of your job. And that's something that Microsoft determined it was not willing or able to do. Importantly, the only accommodations that Mr. Thompson requested, but that Microsoft was not willing to provide, are these few accommodations that Microsoft determined were unreasonable and which Mr. Thompson has never complained about being or never argued were reasonable before the district court and has waived the ability to do so in this court. So there is no need to send this case back to the district court to potentially impanel a jury to hear a failure to accommodate claim in which the only accommodations that were not made but were requested were accommodations that are indisputably unreasonable. Turning to the discrimination claim, Your Honor, I think you've got it exactly right in terms of the timing here with respect to the adverse employment action. We were really in a preliminary stage, a stage preliminary to the ultimate adverse employment action, when Mr. Thompson voluntarily withdrew from the process and decided he didn't want to participate. At the end of that job reassignment program, if it was in fact the case that there was no job that Mr. Thompson was qualified to perform at Microsoft, then at that point he would have been terminated. And that, of course, would have been an adverse employment action, and he could have sought relief at that time. But instead what Mr. Thompson did is say, when he was placed into that job reassignment program, which is what he wanted to happen the first time he disclosed a disability, by the way, a process that he actually went through and participated in to get his current job, when he was placed back in that program the second time, he said, no, I'm not participating, I'm not applying for any job, and that was based on restrictions that he put on himself. He was unwilling to take a pay cut, unwilling to relocate, very focused on a small subset of jobs in the Austin area, whereas the first time he participated in this program, he was applying for enterprise architect jobs all over the country and relocated from the New York metropolitan area to Texas in order to take one of those jobs. But by voluntarily walking away from that process, he pre-terminated the process before it could get to the point of the ultimate adverse employment action.
This case is about the actions Microsoft has already taken. The briefing refers to him being in some sort of disability status. I don't know if that means Social Security or whether that's a status at Microsoft that makes him a continuing employee. Is he an employee of Microsoft as of this point?
He is an employee. He remains an employee. He has been on a disability status essentially since the end of 2016 when he pre-terminated that job reassignment process.
How would that fit in? I know you make the argument that he's a disabled, at least in terms of some of the way that can be declared. It is at least inconsistent as a matter of evidence, not necessarily preempting his claim, but it is inconsistent as a matter of evidence. What role does the fact he's still an employee with whatever Microsoft might decide to do in the future? Offhand, I don't see that it has any relevance to what we need to decide here now, does it?
I think the first point that you made is definitely relevant. That's the Cleveland argument, Justice Breyer's opinion.
Well, you have very different views of what Cleveland means. It does seem to me at least means it's some evidence that is relevant in the analysis, even if it doesn't, as we had said in the Fifth Circuit opinion, that it in some way precludes the claim of being able to handle with a reasonable accommodation. So it is some evidence. But beyond that, is there any relevance to the fact he is on this status and still an employee of Microsoft?
I mean, I think the fact that he's still an employee is evidence to suggest that there was obviously no ultimate adverse employment action taken. He was not terminated because he pre-terminated that process early. Typically, you would see the termination as the ultimate adverse employment action leading to the filing of the lawsuit. That obviously hasn't happened here. And by withdrawing from that job reassignment process, the suggestion is that it was Microsoft's burden to identify a different job for Mr. Thompson to be placed into. That would be true if Microsoft wanted to force a job reassignment on someone. But the way that Microsoft's job reassignment program works gives the employees more agency than that. And it allows them to choose the reason that it's important to get the employee involved in that process is that Microsoft isn't conducting any kind of medical evaluation here. Microsoft is in the responsive role of responding to what the employee and his or her medical providers represent about the nature of his or her disability. So when, for example, Mr. Thompson submits his Microsoft accommodations request form, and on the first question there, filled out by his doctor, the doctor says Mr. Thompson has a disability that affects his ability to perform one or more essential functions of his job. Microsoft is going to take the doctor's recommendation at his or her word and accept that determination that the individual can't perform one or more essential functions of the job. And of course, here, Mr. Thompson confirmed that himself, acknowledging that he needed all of the accommodations on his list in order to perform those essential functions, including accommodations that Microsoft determined were not reasonable. I want to return just for a second to the qualifications issue because I think it's an efficient way to dispose of the bulk of this case, that is the failure to accommodate claim and the discrimination claim. The district court did something interesting in its opinion. Magistrate Judge Lawson, in his report and recommendation, claimed to be that he didn't need to reach that qualifications issue. That's page 210 of the opinion, his opinion. But earlier than that, in page 206 and 207, what the court held was that Mr. Thompson was, quote, unable to perform the essential functions of the enterprise architect role, even with reasonable accommodations. That's a finding on the qualification issue, because if you're not able to perform all of the essential functions of the job, with or without reasonable accommodations, you're not qualified. And that's dispositive of both a failure to accommodate and a discrimination claim. The district court understood that the evidence presented to it at the summary judgment stage conclusively established that Mr. Thompson wasn't qualified for the enterprise architect job precisely because there were admittedly unreasonable accommodations that he would need in order to perform those job functions. And so the way out of this, at least one way out of this case, is what the court did a couple of months ago in Weber versus BNSF Railway Company, not cited in the briefs because it was decided in February, but the citation for the court's benefit is 989 F3rd 320. It was a summary judgment failure to accommodate case in which the employer, BNSF, offered the court a number of possible bases to affirm the summary judgment that it had obtained in the district court below. But this court shortly and simply resolved the entire case on the basis that the employee wasn't qualified because he had not proven that he was capable of performing all of the essential functions of either one of the jobs at issue with or without reasonable accommodations. The same thing is true here. I've already referenced the direct representation that Mr. Thompson himself made in talking with the benefits personnel, as well as the forms that his doctors filled out, such as the form on page 1311 of the record and the accompanying accommodations there. I also wanted to touch on the suggestion raised by opposing counsel that Mr. Thompson could just make other arrangements for any needs that were not being met by the proposed accommodations. What that told Microsoft is that the employee was not capable of performing the essential functions of the job unless he got these other accommodations provided to him. And the suggestion that necessary accommodations cannot be provided by the employer and the employee will just go out and get them on their own, what that does is it confirms to the employer that those are necessary accommodations. And because Microsoft had determined that those necessary accommodations were not reasonable, it was therefore left with no other conclusion than the conclusion that Mr. Thompson was not qualified for the enterprise architect position. And so at that point, there's nothing left to do but attempt to find some other job which he is qualified for and which he could perform, either with accommodations or without accommodations, depending on the particular job and what Mr. Thompson wanted to do in terms of approaching it. And that is the point in the process at which Mr. Thompson backed away and withdrew on his own. Briefly on the hostile work environment claim, it has not been a major focus of Mr. Thompson's argument here today, but I do think that it's important for the court, when looking at those few allegedly hostile acts that form the basis of that claim, we're talking about a series of isolated incidents that really occurred over a matter of days here. When Mr. Thompson makes his initial disclosure of his disability for the second time, to his enterprise architect manager and then says, by the way, my disability impacts my ability to do this job, so I need some forms of accommodation. That is the point at which the manager makes these comments that you've heard referenced in terms of, well, perhaps you should seek a different job, which was exactly, by the way, what Mr. Thompson's doctors recommended that he do. For example, we know from the evidence in the record that Mr. Thompson's doctors were saying that an appropriate job for him would be a job where he works primarily with computers and where social interactions are limited. His doctors also recommended that he avoid having a lot of verbal communication as part of his job. The enterprise architect job is an executive level sales job. There's no way to design that job to avoid social interactions or to avoid the kinds of difficulties that Mr. Thompson faced because of his disability. If you were to look at a list of Mr. Thompson's challenges that he faces because of his particular placement on the autism spectrum and try to design a job to be minimally compatible with that particular list of challenges, you'd end up with something that looks very similar to, if not identical to, the enterprise architect position. And both Mr. Thompson's doctors recognize that, as did the benefits team that was leading Microsoft's efforts to negotiate the possible accommodations with Mr. Thompson. They came to him and said, look, this job that you're in, it sounds like it has all of the challenges that your doctors are telling you to avoid and ask you to do all of the things they're telling you you really are not able to do because of the way that your condition impacts you. And the way that Mr. Thompson proposed to work around that was to have Microsoft hire these other employees to perform portions of that job on his behalf so that he didn't have to do them.
Mr. Thompson, Americans with Disabilities Act is meant to deal with the reality of the kinds of problems that you're talking about. People with disabilities of one sort or another being accommodated so they can live as normal a life as possible. Microsoft was willing, through forced placement, to put this person in an EA position, even though what you're talking about was probably known, I think the record supports, by those who were willing to let Mr. Thompson pursue this. So I don't think there's anything in the case law that it would be more expensive for the employer to accommodate, such as additional help that other people in that position would not need. I mean, I'm not saying it's the overall answer to this, but it does seem to me that the difficulty of the accommodations that he wanted doesn't really resolve whether Microsoft had to consider those, pursue those, and maybe even implement those. Why is, I know you say this is a particularly poor fit in your position, this position, EA, for the plaintiff. That being said, and may even be true, what is the fundamental problem with requiring Microsoft to provide these additional accommodations? Even if they were done, you still couldn't perform? Is that where you come out?
That's exactly right, Your Honor. That is what Mr. Thompson represented to Microsoft, as well as what his doctors confirmed, that he needed all of the accommodations, including the accommodations that Microsoft determined were unreasonable in order to do his job. So when Microsoft determines that there are some...
I know there's a fact finding here that he couldn't perform, a district judge, based on this record, that these accommodations were unreasonable. But I mean, that seems to me is ultimately as part of the decisions we have to make. Does the evidence really support that these accommodations were unreasonable? And were they unreasonable because of expense, unreasonable because of whatever else, complexity, or were they unreasonable because even with them, he still would not have been an efficient, effective EA?
Solely the latter, Your Honor. The reason for Microsoft's decision was that the provision of these particular accommodations that it was unwilling to provide would have excused Mr. Thompson from performing essential functions of the job. So could he have operated as an EA? Technically, because there would have been other employees performing essential functions of the enterprise architect job on his behalf. And that's a level of unreasonableness that the ADA does not require an employer to go to in attempting to accommodate an employee.
Thank you. Proceed.
May it please the court. Your Honors, I want to point the court to record site 1178. It's really important to this question about whether the past interactive process has any relevance. What 1178 shows is that Mr. Thompson withdrew his request for reasonable accommodations the first time around when he was in the prior role as an ATS. What Microsoft's asking this court to do is to change the process for reasonable accommodations, because what this court has laid out in cases like Jenkins is an employer only has a duty to make reasonable accommodations when they've been asked by the disabled employee to make them. What they're trying to change it today is, if you're disabled, then an employer has an ongoing duty to provide reasonable accommodations even when they're not asking for them. That's essentially what they're doing by saying all this past history matters when Mr. Thompson withdrew his request for reasonable accommodations. And let's be clear here, that's why he became an enterprise architect. That's what the record shows. It wasn't because he received a reasonable accommodation, it's because he withdrew his request for reasonable accommodations. The only time people at Microsoft think him being an enterprise architect is a poor fit is when it's known he has autism, when he was first applying for an enterprise architect job, and when his boss found out, when he revealed to his boss that he has autism in January of 16. The record shows, and this is precisely why there's a fact issue, beyond those points, when no one knows he has autism, he's 2 thumbs up. He's a perfect fit. He's done great work. When it's known he has autism, that's when Microsoft endeavors to change his job duties and to ultimately remove him from the position. And that's another problem with their argument, because what they're saying is only if they had fired him would there be an adverse employment action. But Rizzo directly contradicts that. The bus driver was not fired from the learning center. The bus driver was just moved from bus driver to cook. And what this court said is that could be an adverse employment action, or it could be a reasonable accommodation. There's competing evidence, and a jury will have to decide that, and that's what we're asking this court to do here. Now, the last thing about whether he was qualified, again, the record shows that he had done the job well. The only way to find that he didn't would just be to infer the evidence in their favor, which is the opposite of a summary judgment standard. The reality is there's a lot of evidence in the record to show he had done a fine job, and in reviewing through the summary judgment lens, that requires a reversal for trial. And it's precisely for these reasons we ask that this court reverse the trial court's summary judgment.
All right, Counsel. Thanks to all 3 of you for helping us understand this case. That is the final argument for this morning. We are in recess. Watch out for the screen. Oh, it's right up here. Right into.